Ladies and gentlemen, it's week number 2 of the Chauvin trial and the death of George Floyd, and it's been a very weird week, right? Okay, because both sides have scored points, and it's very obvious that Eric Nelson, the defense lawyer for Derek Chauvin, he's kind of getting tired. It's getting pretty obvious, and I don't want to set this up as some sort of an excuse. He had a fantastic week, all things considered. It's only him on the defense's side. And then over on the prosecution, I think that there's upwards of a dozen different prosecutors that can just cycle in, okay? They don't have to keep track of everything that's going on. If somebody's having an off day, the white guy can come in, okay? And then, you know what, if he decides he's going to stumble, or, you know what, maybe he's going to take the morning, and then the lead prosecutor, the black guy, can come in the afternoon, or on Tuesday, let's say, those two guys just don't decide that they don't need to show up for the rest of the week, so they can just hand it off to the couple of women that are there. It's what they can do. They have all the resources in the world because they want to make an example. That was prime evidence of what we had there when all of the charges initially started coming down. We're going to get Keith Ellison, the Attorney General of Minnesota, wanted first-degree murder and, I don't know, just hang him up in the gallows. Everything that could have possibly been charged against him was tried, and eventually we all know the charges that stuck, right? Second-degree and third-degree murder and second-degree manslaughter. That's what we're discussing right now, and they brought, this week was a bunch of the prosecution's expert witnesses, okay? And if you guys are also paying attention to this at the same time, I pop in every now and again into the feeds, but instead I just like to read it, right? And then if I see something that piques my interest, I go and I check out the clip. And that's kind of what we got here, because I heard that, once again, another week, another excellent showing by Eric Nelson, the defense lawyer, which it really just hasn't changed. The dude is excellent, okay? But towards Thursday and into Friday, starting to slow down a little bit, getting way too many facts in his head, and he's a guy who has to be there for 7 or 8 hours a day. Meanwhile, like I said at the beginning, the prosecution can just pass the baton if somebody isn't necessarily standing up and doing the best for their position. And as good as Thursday and Friday looked, when we'll get into that, they should have been presenting this kind of front for the first 2 full weeks. Anyways, these were all the prosecution's expert witnesses. I'm not too sure what we're supposed to be looking at next week, but I know that the defense is supposed to have their expert witnesses. They're supposed to have all of their evidence come forth very, very shortly. And unless Nelson has a stroke between now and then, he should continue to look very good through the end of this. But enough preamble. Let's get into day 6. So we got Monday right here. And the most notable witness that came up was the chief of police. And that's a bald-headed individual you've seen right there, Chief Madaria Adirondo, native Minnesotan. And let's not get this twisted, right? The chief of police is still a police officer. But when was the last time that you got pulled over at a routine traffic stop and the chief of police was there? Obviously, that doesn't happen because chief of police, they're just pencil pushers, okay? They just look at situations, and by situations, I mean pieces of paper, and make administrative decisions, right? So we'll get to Chief Arredondo's questioning from both sides and provided by the wrap-up that is done by this site right here. We got all the way through Thursday, and then we got a different source for Friday. But anyways, the first thing it's important to know about Chief Arredondo is something that's true of every police chief everywhere. Being a police chief is a profoundly different job and state of being that is being a patrol officer. It is not merely that the chief is chief executive officer in a system in which the patrol officer is a factory worker with profoundly different job responsibilities and perspectives on their day-to-day work life. More important than all of that is that a police chief, and indeed in the most part of police officers of lieutenant rank or higher, are effectively political officers working within a political environment, and none more so than the chief. Exactly what I explained at the beginning there, but you don't have to take my word for it. You can take the word of this fellow as well. Direct questioning of Arredondo was conducted by Prosecutor Schlechter, and Schlechter returned to his earlier emphasis on the soft values of the Minneapolis Police Department: compassion, dignity, guardianship, respect, be courteous, be polite, and so forth. Because the facts are very, very loose, we can say, for the prosecution. They don't really have a whole lot of stuff that they can point to directly and be like, aha, that was exactly what caused Floyd to die and Chauvin was directly responsible for it. We'll get to those claims by day 4 this week, but they have to bang the emotion drum. Because there's a saying in the law world, if you don't have the facts on your side, you bang the emotional plea. If you don't have the emotional plea on your side, you bang the facts. And if you don't have either, you bang the table. The chief testified that the mission of the Minneapolis Police Department to treat people with dignity, respect, above all else, really above all else, above preserving innocent life. Cool. By Schlechter telling, with Arredondo's agreement, the job of the police department was mostly touchy-feely, and use of force was apparently an implicit indication that the officer involved had failed to do the right touchy-feely stuff. Schlechter spent considerable time walking Arredondo through the Minneapolis Police Department's use of force policies, as well as several times having the chief read aloud highlighted portions of policy manual. And this is very important on this, right? Because they'd be running down different points on there. He would ask the chief to read, okay, what is this? Okay, and then read a description of the different hold or the different tactic that you're supposed to use. Like, if suspect doing this, then do that. Okay, what do you do in that situation? Please read these 2 bullet points at the bottom. Sounds like pretty standard stuff, right? Well, there was more information on those lines as well. And that's what Nelson, when he was cross-examining the chief of police, that's what he was all about. Nelson emphasized how far removed Arredondo was from hands-on policing. Indeed, given the hedging of Arredondo's experience, it seemed to me likely that he'd only ever physically arrested a very small number of suspects before managing to get himself promoted off the street. I wonder how he accomplished that. Nelson got the chief to concede that his expertise on MPD use of force was at a policy level and not a tactical hands-on training level. He could speak to the MPD's policy might allow or prohibit, but his knowledge of how the officers were actually trained or what they were obligated to do on the street in carrying out their duties was not a topic of which he could claim great knowledge. So why is he being brought up as an expert witness if he's not too sure how different beat cops should be approaching and should be handling different situations? Weird, huh? But he's got the chief next to his name, therefore he's got to be a credible witness, right? Right? Ugh, not so much. Several times during the cross-examination, Nelson made use of clever gambit. I've seen him use once or twice in the state's other witnesses, especially those claiming some level of expertise on relevant issues. When the witness realizes that Nelson was leading them to a conclusion with which they didn't want to agree, they start hedging their testimony. Exactly, adding in those little weasel words. That's something you can pick up on. And whenever we take a look at different articles from different sources, and frankly, you should be using that on every article that you come across or every news story that you listen to as well. You should be listening for those little weasel words, those little outwords, right? Like sources say, instead of just this person says. They have explicit information in such capacity. Nelson would suggest that perhaps it would be better to defer to a specific question to say a use of force expert. A witness would readily agree because they saw this as an escape for the question that they did not want to be compelled to answer. Yes, so if the prosecution was wanting them to speak on something that they should have a cursory or functionary understanding of the topic in which they've been asked the question about, instead of being concrete in their answer, Nelson would walk in and give them just a little bit of a wiggle room. And because the prosecution has provided a whole host of witnesses, like there was 3 today, but the only one of import was the chief of police, they could always just defer to somebody else. Nobody would have to take responsibility. And if nobody's taking responsibility, how can you prove your case, right? All you have is a bunch of hearsay. And it's not a situation of where there's smoke, there's fire. It's more looking like a bunch of people, I would say about 12 or 13, standing around in the parking lot, kicking up dust, making it look like smoke, and then searching for the fire. That's what Nelson has been great about. And then getting into the restraints. That's another thing that Arredondo was talking about. Nelson got the chief of police to explicitly agree that that just because a suspect was handcuffed did not mean they were no longer a threat to officers, others, or themselves. Interesting. Indeed, Arredondo explicitly agreed that the handcuffed suspect would still be a threat to officers by kicking, biting, spitting, or other means. Hence why he was on that man's neck for 9 minutes and whatever fucking 29 seconds. There was a great deal of discussion about neck chokes, which means airway chokes in this context, versus neck restraints, which include both constrictive neck restraints intended to cause loss of consciousness permitted only under deadly force circumstances on the one hand, and neck restraints intended to, well, restrain the suspect without inducing loss of consciousness permitted when dealing with non-compliant suspects on the other hand. With respect to the neck constraints, either arm or leg constriction was explicitly permitted by the Minneapolis Police Department use of force policy at the time. They've since remedied that situation not long after this went national. Hence why everybody found out the maximal restraint technique, whatever the knee on the neck was, right? Which I think we talked about last week. The evidence is starting to come out where it didn't look like the knee was on the neck the entire time. Kind of the crux of all the fucking riots that happened last year. Yeah, it was shifting a lot between the shoulder and the neck, right? And by the neck, we're talking like trap area. So yeah, there's links to the testimony in all of these articles as well, but that was the gist of it, right? For the prosecution, the chief of police was asked to read the different policy and the different techniques that the officers might use in a different situation, and then Nelson would also point out that, hey, there's a little bit more in those descriptions right there. You care to read along? And then also asking him, how much of this stuff do you actually know? Well, not a whole lot. I just kind of sit behind a desk and I do press conferences every now and then. Yeah, so credible witness? Perhaps. As expert as the prosecution would like him to be? Not really. Moving on to Tuesday. Two things. Disaster. Total disaster for the prosecution, right? They looked about as bad as they possibly could because one of their star witnesses, you can see it right in the middle of the screen, Maurice Hall. Yeah, he was the drug dealer who was in the vehicle, and he provided a statement. But we'll get to the overall encapsulation of what's been provided for the day. Today was a terrible, horrible, no good, very bad day for the prosecution to a degree that I haven't seen since the trial of George Zimmerman. Yes, that was old Skittles and Sprite Trayvon Martin. We got to get our soft drinks correct. If you have no more than an hour to watch the video of today's proceedings, I urge you to spend 44 minutes watching the cross-examination of state witness Johnny Mersel, the state's use of force training expert, and 22 minutes watching the cross-examination of Nicole McKenzie, the state's medical care training experts. In both instances, the results can only be called a train wreck of a disaster of a prosecution. Yeah, that guy, it was all looking good for the prosecution until Nelson and his total chadness walked in and made it look like an overdose death. There's no other beautiful way of putting it. It's just, yeah, by Tuesday, things were looking awfully fucking grim. Indeed, after the judge dismissed Mersel from the witness stand, Prosecutor Schlechter appeared visibly shaken and angry. That's where that picture comes from. He looked like that after one of his most important witnesses came up there and totally had to answer truthfully, but it kind of destroyed their case for a minute. Even worse, not only did the cross-examination of McKenzie go so badly, for the prosecution, it went so badly that Nelson informed the court that he had intended to recall McKenzie as a defense witness when he presented his case in chief. Yeah, so we'll be seeing more of him next week. Kind of fucking hilarious. Yeah, we'll get to him after we get to the drug dealer, Maurice Hall, who was in the Mercedes-Benz right next to George Floyd, who was the guy who gave him the pills, right? The one that George Floyd's girlfriend at the time said provided them pills in the past that made them act this way, that contributed to the overdose of Floyd in March, not the one in May. But those were the pills that he got, and they also showed up in the back of the squad car. We're going to be jumping ahead a little bit, but I needed to go ahead and give you guys that little bit of information. So Maurice Hall's Fifth Amendment argument. Before the jury was brought into the courtroom, we heard some discussion about the complication of Maurice Hall, the reported drug dealer in Floyd's Mercedes SUV, announcing he was going to plead the fifth if he was called to testify in the Chauvin trial. By pleading the fifth, that means you cannot provide testimony that would incriminate yourself. Now, why would you be doing that? Well, if you think that you can be charged with, let's just say, third-degree murder for contributing not directly to the death of somebody, but something that you provided to them could have resulted in their death, you're going to want to stay off the witness stand, and that's what he's doing right here. So he sent in his lawyer to say, listen, you're going to have to drag me here if you want me to come in. He provided Floyd with the drugs that likely were actual cause of death. Under Minnesota law, Hall is looking at third-degree murder. Naturally, he doesn't want to testify in the Chauvin trial only to the have that testimony used against him in his own trial, which is his right under the Fifth Amendment. There's no doubt that Judge Cahill will respect Hall's right to assert the Fifth. The only question is whether there might be some areas of questioning in which Hall could participate that do not incriminate him. Yes, there might be a list of questions that the prosecution and that the defense could be bringing up, because obviously the prosecution is going to want to skirt away anything that Maurice Hall might be guilty of in this situation, but the defense is definitely wanting to push everything on to him, right? Because that's the entire crux of their situation. Listen, there were 1,000 underlying health conditions for George Floyd, right? There are a ton of reasons that he could have died from a drug overdose, and that nearly the hold that was being placed on him was of no threat to anybody of healthy mind and body. So a drug dealer, yeah, that could install some reasonable doubts, you might say. We're going to read some of Nelson's cross-examination of the force expert Mercil here. Nelson also once again put the use of pressure and bodyweight techniques in a favorable light. The state wants to present Chauvin's knee in a negative light as deadly mechanical asphyxiation, or as a blood choke, as testified, or as a test to by the karate expert from last week, if you guys remember. In fact, however, it is the use of pressure and body weight to restrain a suspect was adopted by the Minneapolis Police Department because it was a lesser intensity of force in the prior practice of using strikes, either bare hand or with batons or even with weighted gloves, to compel compliance. Mercil concurred. The take-home message for the jury is that Chauvin's knee, far from being a public execution in the street, was a lesser force than would otherwise have been required, whereas Schlechter wants to pretend that all of Chauvin's use of force and other decisions should have been based solely on the needs and desires of Floyd. Nelson once again had the state's witness concede that under MPD critical decision-making model, the officer must consider a wide breadth of factors beyond just the suspect, including the officer himself, his partners, any bystanders. You guys remember the massive crowd that was getting rather rambunctious towards the middle and end of the entire situation. Have to take them into account, especially angry or threatening bystanders. Yeah, right there. Schlechter had also, the prosecutor in this situation, had described use of force in a very static and binary way, which is a sign of an idiot. Once a suspect stops resisting, the officer should immediately stop his use of force, period. But Nelson got Mercil to agree that if a suspect had been forcibly resisting the officer only moments before, that would be a factor in weighing in favor of continuing to apply force even after apparent resistance had ceased. Yeah, and they also would have known based on the call, once they figured out who the guy that they're dealing with is, that he has a violent history, ergo the more common use of force with the stronger techniques to subdue him. So, as you can see, that's just pretty brief, but he was pretty much just going along with what Nelson wanted to say, because what Nelson had to say in this instance was true, right? He was just following orders. Wednesday was more of the same, right? You have this guy here. He is an LAPD sergeant, and he is paid several $1,000s to write a report that Chauvin used far too much force. He was excess use of force, but then he crumpled under cross-examination until this point. This point included. We're not into Wednesday yet, or to Thursday yet, sorry. This is Wednesday. The first shocker in all of this was, despite the huge significance of this case and the national profile it has seized, the state apparently managed to choose a use of force expert witness, someone who had never testified in any state or federal court as a use of force expert. Can you believe that? Well, if somebody's going to go ahead and write you a report, or a portion of a report, that will tell you exactly what you want to hear, you probably want him to say it verbatim in court, now wouldn't you? Now, if you're thinking, I mistyped that, so yeah, he'll repeat that. Sergeant Jody Stinger, the state's highly paid use of force expert, retained to share his expertise with the jury in Minnesota v. Chauvin, one of the highest profile police use of force prosecutions in American history, has never before testified as a use of force expert witness in any state or federal court. the fuck are you guys doing other than wasting taxpayer money? Nelson touched on the fact that Stinger's entire professional use of force expertise was with the Los Angeles Police Department in the state of California, and not the use of force laws and policies of Minnesota. Yeah, because this guy was brought up, not by name, in the opening statements by the prosecution. Oh, we're going to have this use of force expert come through. He's from Los Angeles and he knows all the ins and outs. It's like, well, if you could just get somebody from, in-state, somebody who would have to use these laws and policies, why wouldn't you just get one of those? Oh, this guy's obviously telling you something that you want to hear. Showing you how unqualified this guy actually was, and an immediate regret set over the prosecution's face when they realized that, oh fuck, we were duped for like 5 digits worth of taxpayer money. In the context of the MPD training and policy materials he considered in coming to his opinion, for example, Nelson managed to disclose that the many videos embedded in MPD's training slide decks were never considered by Stinger. Why not? Because Stinger had received PDFs of those slides, right? Just an Adobe static data sheet, right? You can just pull it up, take a look at it, read the page. Okay, that's fair, right? But when you're getting videos, and when you say that you reviewed everything that was sent to you, how do you view videos through a document reader? Oof. Fucking oof. So this guy was saying that, the knee on the neck area, that's definitely what killed Floyd. But you know what killed this guy's witness testimony? The fact that he watched videos through a fucking Word document. Yeah. Sucks to suck, pal. Now we get to the main event. This motherfucker right here, Dr. Martin Tobin. Tobin, who gives a shit? This dude is the Lord and Savior of the respiratory system. Literally, he wrote the book on it, and he gave some damning testimony. And Nelson was having an off day. Terrible confluence of events, but them be the breaks sometimes. Dr. Martin Tobin, physician in pulmonary and critical care medicine, Chicago, presented as an expert witness on respiratory matters. He was followed by forensic toxicologist, as well as an emergency medical physician and self-described police surgeon. If anybody has a nickname for themselves that they've given, I don't know if that makes them any less credible, but it makes me think that they're total douchebags. So a couple of interesting points about Dr. Tobin up front. First, although he normally charges a substantial fee, $500 per hour, hey, if you can get it, it's a good living, for acting as an expert witness in court, he agreed to provide his services in the case for free. Interesting. His explanation was that he's never been an expert witness in a criminal trial before, so he didn't want to charge. I suppose that's could be why. Alternatively, I suppose it's possible he's motivated to do the job free for political reasons. That could be, but he could also just be a good guy with a whole bunch of information that he's just willing to hand over. Hey, man, he probably already made his money through his book sales, so fucking whatever. You do whatever the hell you want, right? Second, while Prosecutor Blackwell, man there at the bottom of the screen, was talking Dr. Tobin through his background, training, education, expertise, and all the other stuff to qualify your expertise in front of the jury. Dr. Tobin mentioned that a chunk of his practice consists of treating patients who require mechanical ventilation due to a variety of underlying causes, including drug overdose. Interesting, considering what he had to say. Third, Tobin would arrive at his expert opinion after watching videos of the event literally hundreds of times, as well as after leisurely reviewing perhaps thousands of pages of investigative reports, forensic results, medical history, and more. None of that, of course, was available to officers on the scene as they fought an intoxicated 6'6", 230-pound Floyd as he violently resisted lawful arrest in the presence of a hostile and threatening crowd. As they waited for the code 3, lights and sirens requested paramedics to finally arrive on scene. In any case, Tobin gave Prosecutor Blackwell on direct questioning exactly what they needed from him, and that was an expert opinion to a reasonable degree of professional certainty that what killed Floyd was impaired breathing as a result of sufficiently low oxygen levels to his cause of death as a result in the manner in which he was restrained by Chauvin and the officers. Yep, he said that Floyd died. Remember, this wasn't the guy who did the autopsy or anything like that. And this is the expert, right? I'll show you. There's a little picture of him. That's his book, Mechanical Ventilation. Big, thick, impressive textbooks. Hot, right? And he said that Floyd died from a lack of oxygen in his blood system as a result of the restraints of Chauvin and the other officers holding him down. Pretty damning, right? And here's another big brain take that he made there. I just wanted to switch it up just for posterity's sake. A pivotal moment in Derek Chauvin's trial. Dr. Tobin says that George Floyd's pre-existing health conditions had nothing whatsoever to do with his death. He is the literal only person who has ever said that, okay? He took enough fentanyl to sedate a horse, okay? He succumbed to wooden lung condition. What is that? Well, that is what happens when you take enough opiate, or to get all technical, a downer in the system, and then you cannot sufficiently contract and expand your chest cavity. And that's what happens with some people who get painkillers in the hospital. That's why nurses need to come in and check on them. And that was something that Floyd was succumbing to. Also, the fact that Floyd had a bad ticker. He had years and years of drug abuse under his belt, as well as rapid ingestion. Not to mention he was also a smoker as well, but none of those pre-existing health conditions had nothing whatsoever to do with his death. That is just a fucking dumb take. I don't care if this guy wrote the book on everything. That is just a misinformed, and several other experts have said that as well. But hey, it was a good day for the prosecution. They got a guy who is number one in that field to say those things that they wanted him to say. So congratulations. And that was a big hit for the day, right? A couple of other testimonies in there as well. But Friday brought out the guy who actually did the autopsy on Floyd. Okay? Andrew Baker, Hennepin County, a medical officer, ruled George Floyd's death a homicide caused by law enforcement restraints last year, told a courtroom on Friday that Floyd's health history and intoxication contributed to his death. What's with the backtracking on your own death certificate, huh? Weird. Floyd, 46, suffered from very severe underlying heart disease that was a factor in the death. No, it wasn't. We just had an expert yesterday, the day before. He said that none of that had anything to do with it ever. Cross your heart and hope to die. As was the toxicology findings that he had ingested fentanyl and methamphetamines. Dr. Baker, the Hennepin County medical examiner, told the trial of former Minneapolis police officer Derek Chauvin. But Baker stood by his earlier conclusion that the cause of death was cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression. Even though there was no evidence of any sort of trauma, no bruising, no constriction to his neck in the autopsy. But yeah, it was definitely the officers holding him down. He experienced a cardiopulmonary arrest in the context of law enforcement. Yes, subdual, restraint, and neck compression. It was the stress of that interaction that tipped him over the edge. What did he need to be tipped over the edge for? Given his underlying heart disease and toxicology status. Nothing like burying the lead there, pal. Cardiopulmonary arrest is really just fancy medical lingo for heart and lungs stopped. Yeah, obviously. Prosecutor and defense lawyers on Friday emphasized different aspects of Baker's findings, with prosecutors zeroing in on how Baker ruled the cause of death was law enforcement actions, while Eric Nelson, the defense god, outlined how Chauvin's health history should read Floyd's health history. Come on now. Chauvin's still very much alive, so he has an excellent health history, and use of drugs were listed as contributing factors, which was also on the certificate after he performed the autopsy. So, as you can see, that was a star witness from Friday. Star witness on Thursday was pretty damning, right? And if you were to only tune in, and if you were only to listen to mainstream sources on that, it would just look like a total and utter home run, right? That was the expert that they needed. They should have brought him in for the previous 8 days, and they should have just kept him on for the rest of the trial, right? But one good day, even if you look under the surface, you know what, really wasn't that great, but they got the headlines out of it that they wanted to. So they went 1 for 10. So we'll see what the defense brings out next week, because I believe that they're going into their expert witnesses and all of their expert testimony, and we'll see if Nelson starts off the week a little bit stronger than how he ended it. It was pretty good with Dr. Baker here, but yeah, he was a tired boy on Thursday. Whatever he's getting paid is not enough, because he's doing a great job. And like I've said before, if Chauvin's guilty, fuck it, don't care, throw him away. You killed somebody, then just go to jail, that's fine. But looking at the evidence, looking at the circumstance, everything that comes out, yeah, I'm not entirely sure about that. I wouldn't be in a situation based on the evidence that we have 2 out of the 4 weeks in on this one. I don't know if I could convict him, because I don't think there's enough information there to really go with anything, especially on the 2 murder charges. The manslaughter one, we'll have to see for the rest of the couple of weeks, but that's my opinion on things, guys. And with that said, it's a long one, but I'm glad you stuck around, and I thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.